Now, from the National Press Club in Washington, D.C., Marcia Clark. The former prosecutor in the O.J. Simpson criminal trial discusses her new book, Without a Doubt, and the details of the Simpson case. Her remarks and a question and answer session last an hour.
Good afternoon. Good afternoon, and welcome to the National Press Club. My name's Richard Salmon. I'm the president of the National Press Club and a reporter for Congressional Quarterly. I'd like to welcome club members and their guests in the audience today, as well as those of you watching on C-SPAN or listening to this program on National Public Radio. We also welcome the audience of Court TV, who's carrying this program live today. Before introducing our head table, I'd like to remind our members of upcoming speakers. Next week, Elie Wiesel, educator and Holocaust survivor and Nobel Peace Prize recipient, on May 20. He'll be speaking about the urgency of intervention, as he calls it, in Bosnia. And our final speakers in May will be Mayor Rudy Giuliani, Mayor of New York, on May 27, followed by Steve Case, President of America Online, on May 28th. Our June lineup includes former President Gerald Ford on June 2nd, John Sweeney, President of the AFL-CIO, on June 3rd, Mayor Richard Daley, Mayor of Chicago, on June 5th, Judge Lawrence Walsh, prosecutor in the Iran-Contra investigation, on June 12th, Senator Daniel Patrick Moynihan on June 13th, Mark Anderson, the corporate executive at Netscape, on June 20th, and Rainier Gut, chairman of Credit Suisse, discussing the settlement of Holocaust victim bank accounts on June 26. Transcript and audio and videotapes of Press Club luncheons are available by calling 1-800-NPC-2334. If you have any questions, and I have a lot of them already, for our speaker, please write them on the cards at your table and pass them up to the head table. I'd now like to introduce our head table guests and ask them to stand briefly when their names are called, and please hold your applause until all head table guests have been introduced. From your right, Herbert A. Sample, Washington correspondent for the Sacramento Bee. Maria Riccio, Fort Worth Star-Telegram. Judy Holland, Washington correspondent for Hearst Newspapers. Vera Glasser, freelance writer. Michael Duggan, managing editor of Knight Ridder Tribune News Service. Judy Foreman, partner Manat, Phelps, and Phillips, and Marcia Clark's personal attorney. I might mention that she also asked to see some of the questions as they were being passed to me, but I got them all. David K. Martin, associate editor of the Thomas Roll Call Report, as well as political finance and lobby reporter, and David is the chairman of the Speakers Committee at the National Press Club. Patty Kelly of Viking Press. Reginald Stewart, contributing editor of Emerge magazine and a member of the Speakers Committee who arranged today's luncheon. Thank you very much, Reggie. Tony Morrow, Supreme Court reporter for USA Today. Clayton Boyce, past president of the National Press Club. And James Carroll, Washington correspondent for the Long Beach Press Telegram and Knight Ridder newspapers. The day after a Los Angeles jury delivered its not guilty verdict in the 372-day double murder trial of sports legend O.J. Simpson in October 1995, USA Today minced no words in assessing the court proceedings. The defense never rested and the prosecution never woke up, the paper asserted, and the reporters at our head table. Tony Morrow. Thank you. The defense never rested and the prosecution never woke up. That kind of criticism plagued the prosecution in the O.J. Simpson trial almost from the start. Most of it fell on the shoulders of today's speaker, attorney Marcia Clark. She was lead prosecutor for the state in the O.J. case, and she got the blame for the loss. During the course of what came to be known as the trial of the century, Clark also drew about as much general attention as Simpson and the other cast of characters in the high-profile trial. For a while, the reporters bored with the proceedings became preoccupied with her changing hairstyle. Looks fine today. At other times, it was obsessed with reporting on her battle with her estranged husband over custody of their children. He asserted she could not work as hard as she was and properly care for their children. If Clark was not reflecting the shortcomings of government prosecutors against well-paid private practitioners, she was the poster woman for the troubles of a modern professional balancing career and family. Through most of it, Clark remained tough and focused. She didn't let many people see her sweat. For good reason. Prior to the O.J. Simpson trial, Clark had won convictions in all but one of more than 20 murder cases. As a member of the special trial unit in the L.A. County District Attorney's Office, she was considered a hardball prosecutor who had worked her way up the ranks since joining the office in 1981. In her personal life, she has also had her own sense of what had transpired between Simpson and his late wife, Nicole. As she mentions in her book, Clark had been raped years earlier while on a trip in Europe and had gone through 2 bad, combative, but not physically abusive marriages. Once the trial ended, Clark left the prosecutor's office and dropped off the radar for some badly needed rest and to begin work on a book just released last week, without a doubt. The $4 million book advance she reportedly received helped solve the wounds of criticism from her peers and gave her plenty of time to reflect. It also gave her the wherewithal to purchase a new roomy suburban Los Angeles house to spend time with her 2 sons, ages 7 and 4. Now, the 43-year-old Clark, a native of Berkeley, California, who has studied and enjoyed jazz, dance, and ballet, is back, and she says she's better than ever. Well, let's find out. Ladies and gentlemen, attorney Marcia Clark.
So, good afternoon. I can't believe I'm here. I actually wrote that in the book. If somebody would have told me 2 years ago that I was going to be addressing the National Press Club after what we'd been through in that trial, I would have said they were insane, but here I am. Let me correct one part of the biography that was just given to you. The marriage that was combative and abusive was my first marriage. My first marriage. Thank you. But in spite of all that you guys have said about me, thank you. I am really happy to be here. I mean, it is really nice to finally be talking to an audience that has absolutely no knowledge and no opinion whatsoever about the Simpson case. Actually, I guess at this point, I'm one of the few who hasn't expressed an opinion yet, but I'm going to fix all that right now. After having spent more than 15 months immersed in that case, I'm going to share with you some of the opinions this afternoon that I have formed. Although I haven't been talking, at least not publicly, I have heard the questions most frequently asked, as you might imagine. You know the ones. Was there a police conspiracy? Why did you call Mark Furman? Why didn't you put on the Bronco chase? And on, and on, and on. Many reasonable and not so reasonable minds have argued about each of them. And just to set your minds at ease, I do intend to address as much of those questions as I can right now, and any that you may pose to me later on. But my message to you today is really that none of it matters. The real crux of the matter is that this icon, Orenthal Simpson, the football legend, who managed to parlay an athletic prowess into a position in the upper echelons of society, one of too few African Americans to have achieved that degree of success, was not going to be taken down by that jury no matter what. And that truth was not something that I learned on the day of the verdicts, ladies and gentlemen. It's what I knew from the moment I read that first questionnaire. By that I mean the questionnaires that the jurors fill out, that we read before we go to select them and talk to them. I'll never forget that moment of painful revelation when the sentiments revealed in the public opinion polls came flying off the questionnaire pages to smash like a wrecking ball right into the wall of optimism I'd built around me so carefully. It was late afternoon by the time our law clerks wheeled in the boxes containing our copies of the questionnaires. And when Bill and I saw those boxes with all those reams of paper, we just stared at each other in complete silence for a few moments. To say that the task that lay before us was daunting would be like saying the ocean is kind of wet. I picked up the first 3 questionnaires, which alone were about 3 inches thick, got out my pens, my colored highlighters, and my Post-it notes, and closed the door to my office, settled down to read. Within the first 20 pages, I knew we had a big problem. We had asked what the jurors thought about various aspects of the preliminary hearing: the evidence, the witnesses, the lawyers. By the time we were at the point of jury selection, it was at least a couple months past the point of preliminary hearing. Lots of evidence had been put out by you guys, and we had put on a lot at the preliminary hearing itself. So it was a good time to find out what opinions they had formed about the witnesses, the lawyers, the evidence. The answers from the first questionnaire to those pointed questions were very carefully guarded. They were worded in neutral, almost indifferent tones. I don't know anything about Mark Fuhrman, and I don't care. That kind of thing. The overall gist was that he hadn't really watched much and couldn't remember almost anything about it. Now, before we even got to the point of drafting the questionnaires, I knew that the kind of intense coverage that the case got could pose a big problem for us with our jurors, and I was wary of potential jurors who would claim to know nothing so they could get on the jury. So I set up the questionnaire with tripwires. And what I did was I seeded throughout the questionnaire questions about general viewing habits. In other words, what channels do you usually watch? How frequently do you usually watch those channels? Which news programs do you watch? Which magazines do you read? Which newspapers do you read? And how often? Stuff that you probably would like to know. And in that first questionnaire, that prospective juror, who claimed to know little, if anything, about the case, described a television viewing schedule and a predilection for tabloids that would have warmed the hearts of station managers and tabloid publishers nationwide. So what this juror would have had me believe was that he suddenly renounced his devotion to news and gossip the minute the Simpson case hit the ground. You can understand my skepticism. I was shaking my head in disbelief at that, but it got worse. When asked what he thought about the Bronco chase, he declared that he had been worried for Simpson's safety and was glad it had all ended peacefully. Now, bear in mind that by this time, you've heard a preliminary hearing, you've heard DNA test results, you've heard about Simpson's blood and the Bundy blood trail, you've heard about blood at Rockingham, blood in the Bronco that belongs to Nicole Simpson, you've heard about the Rockingham glove, you've heard a lot. And what he said about the Bronco chase was not, how about, well, sure, looks like he might have a guilty conscience, or even, I'll wait to see what the evidence shows. I really don't know. No, he felt sorry for Simpson. And when it came to his opinions of Nicole and Ron, no opinion. When it came to his opinions about Orenthal Simpson, a football legend, a hero, an icon. I remember him in Hertz, Naked Gun, sportscaster, a great sportscaster, nice guy, nice guy. That permeated the questionnaire. Well, I finished the questionnaire and I hoped that I'd just gotten hold of an aberration, one from the bottom of the barrel. But as I read the next questionnaire, and then the next, and then the next, I realized that far from being an aberration, he wasn't even the worst. In the next several questionnaires, I went on to read that during the Bronco chase, quote, my heart went out to him. My family was praying for him. I felt bad for all the stress he was under. Now, consider this. In the average case, if this were not a celebrity, if this was not O.J. Simpson, if this was John Smith, who had slaughtered 2 young people and left them bloodied on the ground with all of the evidence that you already knew, and then fled when the police came to take him into custody, would you be saying, and would you be hearing people say, I felt sorry for him. My heart went out to him. I prayed for him. Here was a defendant that in fact was charged with these heinous murders against whom an impressive body of evidence had already been assembled and presented, and the jury pool was not only refusing to consider the possibility that his little Bronco jaunt was a flight from justice, but they were still extremely sympathetic to him, worrying about his depression. And although, by the way, the defense yarn about Fuhrman and planting the glove had been spinning hot and heavy for months by then, I don't think even one of the jurors mentioned that in their questionnaire when they were asked specifically what they thought of Mark Fuhrman. And with each questionnaire that I read, my hope for justice faded. By the time I was through the first dozen, it had vanished completely. I couldn't fool myself any longer. I was fighting a cause that was probably already lost. And I spoke to Bill about that, after we'd spent a couple of days reading questionnaires and gotten through enough of them to see the way the pattern was going. And I'll never forget the depression in his eyes and the sadness. This was a fight for justice that would likely not succeed. But we couldn't hold on to that depression. We could not remain in that frame of mind. So what we did was we found a spark of hope inside ourselves, and we said, all you can do is put the evidence in front of them. All you can do is examine every piece of this case and make the tightest presentation that you can possibly make. Do your very best. And then the rest is in their hands. And we began to fan that little spark into a flame of belief that justice might be served, so that we would have the strength and the courage to go into court every day and do battle. So when people ask me whether the verdict surprised me, I have to tell you, candidly, that it did not. But it definitely did extinguish that little spark of hope that I carried around with me to get me through the trial. And more importantly, it forced me to come to grips with reality. Why did that jury acquit Simpson? We put on enough evidence to convict him 20 times over. More evidence than I think I'd ever seen amassed against any single defendant. And I've prosecuted thousands of cases. So why? And I ultimately had to confront what I didn't want to confront. I would rather have confronted, we messed up, we should have put in this evidence, that evidence, but the truth of the matter was, when I looked at that body, that pyramid board that we put up for the jury of unrefuted evidence, that was the evidence that the defense could not contest, did not contest. That alone was enough to convict him 10 times over. And I looked at that and I said that the answer does not lie in the evidence. And the answer does lie, however, in race and celebrity. It took both. It took both. One without the other, I don't think we would have had any problem. There would have been a conviction. But in tandem, the combination was far more potent than a mountain of the most compelling and comprehensive evidence I have ever seen amassed in any case. But when you think about it, maybe it isn't really all that surprising. Any experienced trial lawyer knows that jurors bring a lifetime of experience with them into the courtroom. There's no such thing as a clean slate. African American jurors are no exception. Caucasian jurors are no exception. With a broad history of 200 years of social injustice and the more immediate backdrop of the Rodney King verdict, there's an understandably different perspective on law enforcement, one that can offer a more receptive ear to defense claims of police conspiracy and corruption. Now add to that the celebrity factor, because you must. Because I prosecuted cases downtown in the Special Trials Unit for 10 years to African American juries against African American defendants and got convictions. So you cannot generalize what you see in this case to all cases. It is an aberration, but that doesn't mean that there aren't important lessons for us to be learning, and learning right now. Add to that aspect I've told you of the social injustice, and now add the celebrity factor. A defendant who is the symbol of success. Not only that, but one with a great PR package of the jovial, affable, nice guy, the smiling athlete in the Hertz commercial, the lovable buffoon in Naked Gun, the friendly sportscaster. He was a hero, not just in the black community, in the white community too. I cannot tell you how many times all men, really not so many women, men, came to me and said, you know, it does look kind of a strong case, but the juice? No, I'm sorry, I just can't buy it. I don't believe it. No one wanted to let go of the image that they were so sure or so wanted to believe was the real Simpson. His fame transcended racial lines. But the fact that he was black added yet another obstacle to the trial, because it heightened the loyalty that we saw in our pool of the African American jurors. Because here was an African American man who had done well, who had made good. From football legend to Hollywood personality, he'd made a name for himself and achieved a level of success that all too few minorities managed to achieve. He was a hero. And now, we were asking a predominantly African American jury to take him down, not just for something as minor as drunk driving, but for murder. and then to go back to their respective neighborhoods and explain to a lot of angry friends and neighbors why the evidence compelled them to destroy a national hero. It just wasn't going to happen. And if you doubt that social history and the Rodney King case in particular more recently factored in heavily, let me tell you about something that happened during the trial. During my questioning of the jury, towards the end of it, I confronted the idea of private agendas head on. I questioned them about their belief in Colombian cartels and the mafia, all the theories that have been floating around. And specifically, I cited the first Rodney King verdict as an example of one that may have been the product of personal bias rather than the evidence. The jurors uniformly admitted that they disapproved of that verdict. It was later reported to us by other jurors that one of the seated 12 jurors had referred to the King case and said, "That's right, it's payback time." The juror was questioned about it in chambers and denied the remark, so the judge allowed her to remain. When the verdicts were read, that was the thought that ran through my head. This was payback time. Now, was that true for all of the jurors? I'm not saying that. Was that true for some of them? Probably. Is that something that we should be thinking about and talking about and looking to resolve? Definitely. We can play Clue all day long if you want, and say it's Mr. Plum in the conservatory with a candlestick, and talk about conspiracies and domestic violence and who we should have called and who we shouldn't have called and the Bronco chase and on and on and on. But no matter how you fit the pieces together, ladies and gentlemen, the result would have been the same. Not guilty, maybe a hung jury, but a conviction? Never. Not with that jury and not with that defendant. So, okay, you're thinking, maybe I'll buy that, maybe I'll buy that, but surely you should have known that you'd get a predominantly black jury downtown and you'd have a hard sell there, so why not take the case to Santa Monica, right? Or, removing the euphemism, why didn't you take the case to a white jury? Well, first of all, because taking the case to Santa Monica, a branch court, was never an option. It wasn't even discussed. The policy of the criminal court judges at that time prevented it. All long cause cases, meaning those cases that would take 2 or 3 weeks to try or more, would not be tried anywhere but downtown. That was the policy. It was a policy instituted to prevent the backlog of large cases, lengthy cases in the branch courts that would have gotten bogged down and unable to handle the regular calendars. That was the whole idea behind setting up long cause courts to begin with. They'd be courts devoted solely to lengthy cases, leaving the rest of the courts to handle the bulk of the routine ones. So we never had that option. But I really even hate to tell you that. I really don't even like talking about that, because the truth of the matter is, I'd rather talk about what goes behind that question. So go ahead and ask me. I'll ask myself for you. So what if you didn't have that policy? Then, of course, we should certainly have filed the case in Santa Monica. Not just because that's the venue, of course, but because then we get a white jury. And to those people I say, really? Oh, really? Is that what we should be doing? Is it? Shopping around for a jury that will convict? If we have a white defendant, then we should go look for a black jury. If we have a black defendant, we should go look for a white jury. Is that the way we seek justice? By shopping the case to a favorable audience? I think we would and should be roundly criticized for doing anything like that kind of maneuvering. And if we did, any conviction that we got would likely be mistrusted by one community or the other. No, that quick fix is not the answer that's going to do us any good in the long run. In fact, it'll do us great harm. What we should be talking about is not how to find a hanging jury, but rather about the painful, yet critical issue of the racial divide and how to end it. We need to get to the core issues that cause so many in the black community to view law enforcement with mistrust and the criminal justice system with skepticism, as a system that either unfairly persecutes or unfairly neglects their needs. We need to bring everyone's experience of law enforcement and the criminal justice system into alignment, because our goal is not to shop for favorable juries. Our goal is to resolve the race issue so a fair jury can be found anywhere for any defendant, regardless of race. But we'll never get there if we lose this golden opportunity that's been presented by this trial to understand that we do not all view law enforcement the same way and that there is reason for that. You cannot dismiss the jury's verdict as a product of a little too much, not enough evidence, or that we should have gone out to get another kind of jury. You should look at the verdict and say, what's wrong here? Why were they willing to believe police corruption and conspiracy? Why was it an easier sell? And why did Johnny Cochran know that? If you think that it did not play a part in the verdict, then why was the defense playing the race card to begin with? It had nothing to do with the case. They obviously thought it would work. Did you think at any point in time that Mr. Simpson murdered Nicole Brown because she was white? Or Ron Goldman? Of course not. So what part did race play in this case? Absolutely none. So why was the defense playing the race card? Because they knew. They knew there was a way to get the jury to view the evidence with skepticism. And they used it. So what I think we need to do is to start talking right now and start listening and figure out how we're going to get our experience of law enforcement into alignment so that everyone perceives it as fair, or mostly fair, so that the criminal justice system is not viewed as something that is only for the majority, so that everyone feels they can get justice under the law, and then the race card won't be played because it won't work. That's what we have to look for. So I know we're going to talk about the evidence, and it's more fun to do that. But I really do want everyone to take that away with them today, because I think it's real important. Because in truth, we did introduce more evidence in this trial, I've told you, than I've ever seen. We called it a mountain of evidence at the time, and I'd like to correct that for you today. It was the Mount Everest of evidence. So the bottom line is that the reason for the acquittal can't be found in the evidence. Now, having said all that, I assume inquiring minds still want to know the who, what, and why questions, so here we go. Question: why did we put domestic violence evidence before a jury predisposed to dismiss it? The problem with this question is that the premise is ludicrous. It's ludicrous because its premise assumes that African American women either don't care about it or don't understand it. Nothing could be farther from the truth. And I can say that because I speak from personal experience. As a prosecutor, I've put domestic violence evidence on before black women. Far from being dismissive, I found them to be both receptive and wise in their understanding of the realities and the significance of that evidence. And the very notion that black women either don't care or don't understand domestic violence is complete and utter nonsense. I can hear you thinking, well, they sure didn't sound very sympathetic to it in the Simpson case. Well, you're right. That's true. But that doesn't justify the generalization that all African American women don't get it or don't care about it. In fact, just the opposite. The fact that some or even all of the jurors dismissed that evidence is only another example of the aberration that this case really was. It exemplifies the kind of denial that the jurors had to enter into to rationalize an acquittal. It's certainly not a standard by which to judge all African American women at all. Question: was there a police conspiracy in this trial? Or more specifically, did some shadowy figures in blue run around sprinkling Simpson's blood all over the place? The answer that I have to that, the short answer, you have a longer answer in the book, is why? You know, why? Why him of all people? Why would they want to plant evidence to frame him? The police were his friends, for God's sake. As Nicole cried in frustration to Detective Edwards, you may recall, after she was beaten by Simpson on the New Year's Eve of 1989, "You've been out here 8 times before. You never do anything about him." The police were known to drop by his home to kibitz, to get footballs autographed, and when Nicole turned to them for help, all too often, they washed it out. They loved him. He was their hero. So what's the motivation? He was no threat. He was the man's man. He was the one that they loved to kibitz with, the one they loved to brag about being friends with. And even after he was taken into custody, he got treated like gold. If the cops wanted to frame him, I ask you, then why didn't they nail him during that interview on June 13th at Parker Center? If they wanted to set him up, then why did they let him go home, where he could destroy any evidence that he'd missed, pressure witnesses, and maybe even flee? Wouldn't they have put him through the ringer during that interview on June 13th if what they wanted to do was frame him. Of course they would. But instead, look what they did. That interview was, relatively speaking, for the interrogation of a homicide suspect, a model of decorum. A grueling inquisition, it certainly was not. Whenever Simpson was asked for details, he got foggy. What time did you park your Bronco for the last time that night? 7, 8, 8, 9. The follow-up should have been, well, what was it? 7, 8, 9? It wasn't 3 weeks ago, Mr. Simpson. It was just last night. Surely you can do better than a 2-hour time frame. But that kind of prodding just never happened. And that prodding would have at least highlighted his evasiveness. But it didn't happen. Instead, he was allowed to slip and slide whenever the questioning began to focus on the specifics of his actions on the night of June the 12th. And then worse than that, the follow-up to many of his doublespeak answers was nothing more than, yeah, I understand, I understand. When the detectives began to discuss the possibility of his taking a polygraph, Simpson's response was very revealing. He stated that although he probably eventually would take a polygraph, he didn't know because, get this, he had had some weird thoughts about Nicole, you know. When you're together that long, you think all kinds of things. I love asking this question to reporters. What would you ask? What would be your next question if you heard him say that? Yeah, what kind of thoughts? You'd ask that. You'd say, oh, really, Mr. Simpson? Well, what do you mean by that? What kind of thoughts were you having about Nicole? You want to know what the detective said? Yeah, I understand. Ooh, I'll bet Simpson was sweating by then. Now, I ask you, are those the actions of police officers looking to frame someone? They had him on the ropes and they backed off. And the whole interview took less than 30 minutes. I have never, ever, in my 14 years as a prosecutor, or my 2 years as a criminal defense attorney, ever seen a defendant treated with the kind of deference Mr. Simpson got from those detectives. And that deference brings me to another point. Why did 4 detectives go to Rockingham in the early morning hours of June the 13th? It doesn't take 4 detectives to make notification to the next of kin. They must have considered him a suspect, and that's why they went over the wall. No. Okay, I'm done. No, I'll explain. Again, we have another example of the special measures that were taken to coddle a celebrity. When those detectives left that bloody scene at Bundy, they were determined to make personal notification and take every step they could think of to take care of Mr. Simpson. Lang and Van Adder would personally notify him because that is the standard procedure you should follow whenever possible. The investigating officers goes to shake the hand of the next of kin. I'm sorry, I'm deeply sorry for your loss. Establish rapport so that they can get eventually into a questioning mode that will give them some of the information that may help to investigate the case. You make that early contact, it helps a lot to establish that rapport. So they were going to make the notification in person. And then once they made notification, they would go back to Bundy. The notification they figured would take just a few minutes because Phillips and Furman, Detectives Ron Phillips and Detective Mark Furman, would take Simpson themselves, escort him to the police station to pick up his children. They didn't want to risk having him drive himself to the police station. They didn't want to risk him possibly driving by Bundy, which would be devastating. Better for everyone all the way around if they took him to the station while Tom and Phil went back to the Bundy scene to do the investigation. Now, was this an awful lot to go through in the middle of all the work that had to get done at Bundy? You bet it was. But this was Simpson, the juice, and he got favored treatment. If you doubt me, if you doubt that that was the reason why all 4 went to Rockingham, then answer me this. If the cops had left Bundy intending to go to Rockingham because he was a suspect, then they were intending to go and make an arrest, right? Now, an arrest, especially of Mr. Simpson, would be nothing if not time-consuming, because then he'd have to immediately be taken all the way downtown to Parker Center. Now, if that's so, and they're intending to make the arrest, and they're going to be gone for a few hours, then why didn't they leave instructions for a supervising officer to call the coroner at Bundy? Why leave the victims lying there for what could have been several hours while precious evidence is lost? If Simpson was a suspect and they intended to make the arrest, at the very, very least, they would have seen to that. But they didn't. They didn't because they fully intended to return within minutes. And that's not all. If they viewed Simpson as a suspect, then why, once they went over the wall, didn't they search the place? They played their flashlights over the grounds. They were looking for other victims, maybe another suspect lurking around, but once they got inside the house, the only action that could remotely be categorized as a search was when they asked Arnell to show them the maid's room to make sure there was no evidence of foul play. So they looked downstairs, visually looked, without even opening a drawer or looking under a mattress. They never even ventured upstairs once they got in contact with Arnell. Now, is that the behavior of detectives in pursuit of a suspect? Well, I don't think so. Instead, try to see it from their perspective. And I know it's difficult now. We all have the perfect vision that only hindsight can give us. But if you can try and strip away all that you know now about what happened later, you be the detective for a moment and picture this. The ex-wife of your hero is lying in a large pool of blood. Blood soaking into the steps above her indicate that she was viciously butchered. A young man lies a few feet away from her, bearing hideous wounds that are the obvious cause of the blood soaking his shirt and pants. This is a scene of incredible carnage. You hear that one of the detectives from West LA might have gone to Simpson's residence on a domestic violence call, but that was about 10 years ago, and you just don't have any further information on it. And it was long before they were divorced. You learn that two small children, the children Simpson had with his female victim, were found sleeping in their beds upstairs at the scene of the crime and were taken to the police station to wait for a family member to take charge of them. You're ordered to go and make personal notification to Simpson before the media can blast it all over the news, and you need to get those young children taken care of. You get to Rockingham, and you see that there are lights on in the house, cars in the driveway, and you think, this house, being a pretty impressive mansion in the tonier section of town, is probably always occupied by a maid. You ring the buzzer at the gate. No answer. You try again. No answer. You look at the cars in the driveway. You look at the lights on in the house. You try a few more times at the gate. No answer. You manage to get a West Tech security guard who patrols the neighborhood to give you his phone number. You dial the number. No answer. You ask the West Tech guard whether Simpson left word that he'd be out of town. No, he left no such word. This is getting troubling. And you've got two small children waiting at a police station with no information as to where any other family members might be who could take charge of them. You remember the Bronco parked outside the house on Rockingham looked like it had been hastily parked. And then Detective Furman comes over to tell you that he's seen a drop of blood on the driver's door of that Bronco. You go down to take a look. Sure enough, looks like blood. All the fears that have been mounting over the past 15 minutes are now sounding warning signals in your head. Whoever killed that woman and the young man might have had Simpson as the primary target. Someone could be bleeding to death in there, and that someone just might be Mr. Simpson. If you wait to get a warrant, it just might be too late. You'll be taken to task for acting too slowly. And here's your chance to be a hero to your hero. So what do? Now, if this were not the juice, I'll bet those detectives would not have been so reluctant to consider the circumstances a little differently. But the fact that it was the juice tilted their perspective. They couldn't match the brutality of the scene at Bundy with their image of the all-American hero they'd revered for so long. And besides, why would he risk losing all of that fortune for his ex-wife? Of course, that leads you right back to celebrity. Now, I was planning to address the issue of Mark Furman and planting the glove, but I know that you'd rather ask me that question yourself. So I'll let you. That's all right. There are a whole host of other questions, but I do want you to remember one thing. It is not as though we forgot. We considered every piece of evidence carefully, and I'll bet my bottom dollar that if we had put them into evidence after the not guilty verdict, you'd be asking me why we did. But I think what is important to do is consider this. Yes, I've made mistakes. Yes, I have regrets. But it happens in all cases, and the jury did come back with a conviction. This case is no different. I wasn't perfect, but if you come away with nothing else today other than a pretty good lunch, it's that none of those regrets or imperfections really made a difference. The case came down to race and celebrity, and the only real regret that I'll have is if we fail to heed the message behind the verdicts in the Simpson case. The time has come, in fact, it's way long overdue, to address the issues of racial divide and celebrity in the manner in which they came to subvert justice, because only then will we begin to move towards the ultimate goal of equal justice for all under the law.
Thank you. Ms. Clark, you mentioned in your speech that you take full responsibility when all is said and done. You also say that the jury pool was poisoned, the judge inept, and the defense dishonest. So what is it exactly that you are taking responsibility for?
You're applauding your own question? I don't say the jury pool was poisoned. You did. I think that the jury pool was overwhelmingly sympathetic. I am pointing out all aspects of the case. I take responsibility for not having appealed the ruling that Ito gave allowing in racial epithets. I take responsibility for perhaps grilling some of the witnesses too strenuously. I take responsibility for all of my actions in the case, the good and the bad. I've never shied away from that. And I did not do a perfect job. And I could probably think of a whole lot more regrets. I always walk out of court thinking I should have said this, I could have done that. But as to the big issues, the big decisions that we made, I stand by them. I have told you here, and I've said it more deeply in my book, what I regret, what I would change if I could. I can only take responsibility for what I do, for what my team does. I cannot take responsibility for the judge's failure to control the courtroom. I cannot take responsibility for a jury pool that was brought in by the jury commissioner with overwhelming feelings of sympathy for the defendant. And I cannot take responsibility for the scheme team. I can only take responsibility for myself, the dream team, you know. And I do.
You mentioned that it's entirely improper to shop around for a jury that is inclined to your side of the case. But how then do you defend peremptory challenges, which in effect is an example of shopping for a jury that will be inclined to your side of the case?
Oh, but that's different. Because a peremptory challenge is a challenge based on your feeling about a particular juror's bias or lack of bias, and it is not permitted by law to be based on racial considerations. So you can use your peremptory challenge if you can show other factors that justified a dismissal of a juror. But if the other side can show that you've dismissed a juror on a peremptory challenge because of their race, you can be cited to the state bar for that. That's the difference.
Question about the two cases. If the judge who presided over Simpson's civil trial had presided over the criminal one instead of Judge Ito, do you think the outcome would have been different?
I don't know about whether we would have gotten a conviction, but I think we probably would have wound up with a hung jury. Yeah, I do think so.
About Judge Ito and about controlling the courtroom, the circus manner that is often applied to it. If Judge Ito was a, quote, dunderhead, as you said, why did you defend him when he was about to be recused mid-trial?
It wasn't mid-trial. It was actually already towards the end of the trial. And here's what we were confronting. If we were to recuse him at that time, with so much of the trial already done, another judge stepping in would have had to take quite a while to get prepared. The very strong likelihood is that we would have wound up with a mistrial, because we would have lost so many jurors during that hiatus that we couldn't have proceeded. It would have wound up being less than 12. In fact, we were talking about being able to stipulate to a jury of fewer than 12 at that point, because we lost so many. Now, if that happened and we had to retry the case, I can hear you thinking, well, wouldn't that be good? You'd get a new jury? Well, no, because now we'd have a jury that, although I was very concerned, and I know the defense felt as well as I did, that the jurors were getting information that they were not supposed to have through conjugal visits, at least there was an outside chance that they didn't get to see Furman take the fifth, all of the McKinney tapes, and all of the other evidence that was not ultimately ruled to be admissible. Our jury pool, on the other hand, was not sequestered. The new people that we were going to pick from downtown would have heard it all. What was the likelihood that we would be able to get a conviction with that next pool? Nil. So we would have wound up with mistrial, retrial, and at least a mistrial, if not an acquittal. That's why.
I have about 30 questions here about something about a glove. When Christopher Darden was here at the Press Club last year, he was promoting his book. He said that the worst mistake was the biggest mistake in the trial was with the glove and trying on the gloves. Do you agree? And also, a related question: why did you let Simpson try on the glove when you knew it had shrunk because of the blood stains?
I really don't know that it did shrink because of the blood stains. My concern was always that the latex underneath would alter the fit. Or if he doesn't pull the latex all the way down, then you have this effect here between the webbing of the fingers, and then you have an impossible fit. That's what I was concerned about. And we were co-leads. I pushed myself to the wall to persuade Chris not to do it, using all kinds of language. But we were at sidebar at the time, and he was with the witness, and we have to, when you have co-leads, you can't have two people running the show. The one who's with the witness has to make the decisions. He was with the witness. It was ultimately his decision to make with the witness. All I could do was beg, plead, threaten, cajole, and I did it all. But he felt that very strongly, that if we didn't do it, the defense would do it, and then it would look bad for us. I felt that if we let the defense do it and it didn't work, I think that would be fine. Sure, of course the defense wants to do it with latex on. That's why they don't fit. I wanted to wait until we got the actual duplicate gloves that would allow for him to put them on without the latex, and I was overruled.
You mentioned the mountain of evidence that was introduced. Lawyers in the civil case say the photos of Simpson and Bruno Mali's shoes were a key factor in their case and the outcome. What difference, if any, would it have made to you if those photographs were available in the criminal trial?
Well, I would have liked it, you know. I mean, we actually presented the testimony of Bill Bodziak, excellent, superb shoe print expert. And he, when he was testifying and he was describing the kind of shoe that made the shoe prints, I really thought someone would come out of the woodwork, you know, but they didn't. The impact, it's really hard to tell. I mean, perhaps everybody's forgotten the evidence that's already been presented. You know, Simpson's hair on Ron Goldman's shirt, Bronco fiber, carpet fiber on the Rockingham glove and on the knit cap, Simpson's hairs inside the knit cap, of course, his blood at the Bundy Walk, his blood in Rockingham, Ron Goldman and Nicole Brown's blood in the Bronco, Nicole's blood on his socks. You don't think that's enough?
At any point in the investigation, did you interview or question O.J.'s younger children? And if so, were they afraid or intimidated by him, or did they appear so in discussions with you?
Can I see that one?
Yeah. In any point in the investigation, did you interview O.J.'s younger children?
Younger children, okay.
Yes.
They were interviewed by police officers. They did not.
Not by you?
No, by police officers. We were attempting to interview them, but we were unable to.
Okay. Mark Furman has claimed in interviews that the DA's office did not interview his partner, who was also at the crime scene. Is this true?
Not exactly true, no. Mark Furman is now saying, apparently, that he wanted us to call Brad Roberts, his partner, to corroborate his statements. Here's the problem. Brad Roberts would have corroborated the existence of a possible bloody fingerprint on the rear gate. The problem with that is they never recovered it, so what are we corroborating? If I was the defense, I would have gone really far with the cross-examination of Detective Furman about why that fingerprint was not recovered. You know, they didn't. They let it go. But the failure, why are we going to highlight the failure to recover evidence? What does it prove? They both saw a fingerprint in blood on the rear gate, but we don't know whose it is. So what are you corroborating? The other thing is that every witness, I looked through the crime scene log and interviewed every witness that was at Bundy before Mark Furman got there so that they could testify to how many gloves they saw in the evidence. There were 4 police officers that got there before Mark Furman that were in a position to see, but Brad Roberts was not among them. So what was he going to corroborate? What could he help us with? Nothing.
I'd like to go back to the discussion of the juries. And given your characterization of the jury pool in Without a Doubt, how would you propose restructuring the jury selection process? You were certainly critical earlier in the program of shopping around for a jury, but what would be an example of how you would approach a new jury system that seemed to take into account the complexities of a lot of cases that are around today, complexities that may not have been associated with earlier cases earlier in this country?
You know, one of the first line of defense is that many, many people throw away their jury summons. You know? Oh, anybody here? You know, you're busy, you've got a job, you've got a family, you have a lot of obligations, I understand, and serving for 6 months on a jury is not something that you really look forward to, neither would I. But if that keeps happening, what we have is a situation where you get a narrowing of the jury pool so that the words jury and selection become a joke, because you're not selecting from anything. You need diversity. And by that I mean I want everything from high school dropouts to PhDs. Not all of one or all of the other. You need everybody and all of that in between. And then you have the possibility of really better verdicts. That happens a lot. So that's one line of defense. The other is that people legitimately, I don't know about here in Washington, but I know in California we have a big problem because employers frequently don't pay for more jury service than 10 days, which means that virtually every lengthy case, and that means usually the heaviest cases, the death penalty cases and stuff, they can't serve. So that you have a whole segment of the population that's completely cut out of your jury pool due to financial hardship. We need to look into getting the government to subsidize for unlimited jury duty for everybody, instead of just having very limited segments of the population who cover for that unlimited jury service. So those are a couple of things we could start with.
Another question on the jury. You mentioned the element of race in the entire trial. But one thing that is not mentioned as much is the murder of Goldman. And did it ever occur to you that a Jewish juror may have influenced the jury consideration and contemplations of the trial?
What?
A Jewish person on the jury.
Oh, if we had gotten
Yes.
a Jewish person on there, I thought you were saying there was one. I was there. I didn't remember that. I really don't know. You know, that comes back to the kind of the considerations that really go beyond the evidence. Would they, in other words, influence the rest of the jury based on their religion? I don't know. I haven't been in that position.
That's fine. You say now that you oppose cameras in the court, in part because of the circus atmosphere that surrounded the trial. But were the cameras really at fault, or wasn't it the way that the trial was controlled from the judge?
Yeah, that's fair. I mean, I've talked to many others about this before, and my feeling is that I don't think that cameras would be so bad if you could guarantee that a judge would not let the case spin out of control, by which I mean that you would not allow for the lawyers to be up and arguing constantly and putting things on the record just so they can get a soundbite, and you would not have people preening in front of the camera, witnesses performing for the camera, lawyers outside putting their spin on the case. If you gag the lawyers, kick the cameras out when the jury's not around, and you really control your proceedings tightly so that people do not behave unnaturally under the glare of the spotlight, then cameras might be an actually educational thing. My problem is that you can't guarantee that kind of strength from the bench.
Did you ever think when your ex-mother-in-law was selling you to the Inquirer and your husband was seeking custody of your children that your whole life gave you rather good material for a book of fiction?
Yeah, who would believe it, huh? I mean, you know, think about this. What, 3-4 years ago, if I'd come up to you and said, you know, there was this prosecutor, right? Mind your own business and step right into this case, and all of a sudden people had, you know, her hair on the 11 o'clock news, you'd say, you know, that's ridiculous. You know, it's not even very good work of fiction. You know, it's unbelievable.
Okay. Well, back to a more serious one. Regarding the trial, would you have sought the death penalty, and would you feel that it was justified, if guilty?
You know, the death decision is a very, very weighty one. It's one made by committee, so no one single person makes that decision in our office. What we do is we consider both the crime and the offender. And the decision was made in this case by the committee not to seek the death penalty. Because what we do is we look at the offender and we say, has a life of crime preceded this act? And the nature of the crime itself, as well as the facts of the case and the strength of the evidence, all of that is taken into consideration, and in this case, it was decided not to seek the death penalty.
Just time for a couple more, but we would like to know why you never called A.C. Cowlings to testify.
Because, I wonder how much of this I can talk about. A.C. Cowlings wasn't talking to us, you know. I mean, that you should know. He wasn't hanging out around my office saying, hey, Clark, you know. So, and not only that, but there were still the possibility of pending charges for aiding and abetting an escape. And so there would be a great number of questions that he simply could not answer that would expose him to liability. And so he would not be taking the fifth in front of the jury either. It would basically be just him sitting on the witness stand and then the jury be sent out, you know. So at that point, we really were unable to call him.
Oh, well, we'll have time for one more. It would have been nice to spend the entire afternoon playing a game of Clue. But we do need to wrap up. But first, I wanted to present to you a sweater from the National Press Club. You can try it on, see if it fits.
I want my latex shirt first.
Okay. And a certificate of appreciation and the world-famous coffee mug. Final question is, Ms. Clark, would you hire any of the defense team if you ever needed a lawyer? And who would it be?
I like that question. First, thank you very, very much, and I don't think I would hire any of them, no. Sorry. Thank you.
Thank you. I do need to say that Mrs. Clark is just received a call to join a jury in New York, and she is unable to stay around very long. So if you could remain seated while she's escorted out. I'd like to thank you for coming, and thank National Press Club staff members Kate Goggin, Joanne Booz, Melanie Abdow-Dermott, and Howard Rothman for helping organize today's lunch. Thank you.